I'm Leslie at OC Wills and Trust Attorneys, the Director of Operations here, and I help manage the staff. I'll introduce Attorney Brian Chu, since he's my boss and the managing partner at our firm here, OC Wills and Trust Attorneys. He started this firm in 2008, so it's great to be part of this law firm. Thank you, Brian. I'll let you take it.
All right, thank you, Leslie, and also we'll be meeting Paul and Harry Barth, who will be speaking later. I want to thank everybody who's joined us today. Some of you are our clients already, and some of you are new to us. For those of you obviously our existing clients, thank you for joining us. Hopefully, this will be some additional information for you today. Some of it will cover some of the things that obviously you've already done. And for those of you who haven't done estate planning, we're going to cover some of the basics as far as basic estate planning and how it protects you. And then Harry's going to talk about kind of your next steps after getting your foundation done, additional things you could be doing to protect yourself and your families. All right. But anyway, just, I'm an estate planning attorney. We prepare wills and trusts and other documents for our clients to make sure that, God forbid, something happens to you, pass on, or become incapacitated, that somebody or chooses in charge yourself, in charge of assets, and for those of us who have children, in charge of your kids. Okay, and so we talk about protection, planning. What we do is protecting your family ultimately. How do you protect your family from how do we protect your family, your assets, and yourselves and or your kids when you can't be in charge? And what I do from the estate planning side in terms of the basic documents that we do for our clients is to do whatever we can to make sure that if something does happen to you, you can no longer make decisions, or God forbid pass on, that somebody else can take over, can make decisions for you involving the least amount of attorneys as possible. Okay, I always tell people my job is to keep the what we call probate or probate attorneys unemployed. Okay, those are the people that get typically involved when you don't do planning. Okay, and that's what we're trying. And so while that's not directly asset protection in the sense of somebody's trying to sue you, okay, it is protecting your family because it's saving your family by not having to spend a lot of money on expensive probate attorneys. And that's what we're trying to avoid. And that's the basic planning we do, is to keep the other attorneys, not having to hire them. And so, the biggest one and probably the most common reason people, hire someone like myself to do estate planning is to avoid probate for their family. Okay, probate is what happens when you don't do adequate planning to allow the transfer of control of assets like your home and or your bank accounts from you to somebody else without them having to go to court. Okay, and the primary reason why the assets are going to court is if you pass on, in this case, and assets are in just your name, like your home, that asset would be subject to what we call probate. And in order for somebody to gain control of that property, presumably some relative of yours, and for them to have the authority to either sell or transfer that property, they would have to go to court and most likely hire an attorney, a probate attorney. And the probate attorney is typically going to charge tens of thousands of dollars in legal fees. For a lot of times, for doing things, again, it's fairly standard. There's not much, most of the time, there's not much argument. And so they're getting paid a lot of money to get you through this probate process that takes 1 to 2 years. So most families want to avoid that. And the best way we have to avoid that for our clients is to create what we call a revocable living trust. The revocable trust is an agreement either with yourself and or if you're married, between the married couple, that says if something happens to you, incapacitate or pass on, somebody you're choosing, what we call a trustee, or in this case, a successor trustee, can take over control of the trust and all its assets if something happens to you. The trust is like a company. You own and control the company while you're alive, but if something happens to you, your company continues on, and what changes if something happens to you is not your trust, but who's in charge. Basically, there's a change in management. Somebody else can now assume control of the trust and all its assets. And we play a role in helping create this trust for our clients, so that if something does happen to you one day, those assets, the control can transfer from you to somebody else without them having to go to court. They just can file paperwork. And while they might have an attorney assistant with that paperwork, the costs associated with doing that paperwork will be far less than what it would hire a probate attorney in that case. And so that's what we're trying to do. We're trying to make it easy, so that people are just filing paperwork to gain control of assets like your home. Now, other assets like financial accounts, you can avoid probate by naming beneficiaries. However, for those of us like myself who have minor children, if we name our minor children as beneficiaries on our accounts, that subject would also still be subject to probate because the court has to decide who's in charge of that money. So that's another instance of assets being subject to probate if even though you're naming beneficiaries, because normally if I name a beneficiary over 18, that is not subject to probate. But if I have minor children, that would go to court. So again, we're trying to avoid that. And the best way to avoid that for those who have minor children is to, instead of naming the trust, instead of naming our kids as beneficiaries, we can now name the trust as the beneficiary on our accounts. So those are the things we assist our clients with in setting up the revocable trust. And that's one of the primary goals of having a revocable trust. The trust at the end of the day is your will. It says who's in charge of assets when you can't be, and how and when you want the assets to go to your children. And then the last part of asset protection, kind of the protection planning when it comes to a trust, is the trust typically is also the best way to control how and when the money goes to our kids. Or whoever we're giving it to, because if you name somebody, as long as they're over 18, they get the money. All right, great. However, it does mean that they do get the money and they control it, and it can control it as early as 18. And that may not be the best plan. I know in my trust says my kids don't get control of the money until age 25, because I trust somebody else's judgment to spend the money wisely if something happened to my wife and I. And so again, indirectly, that is a form of asset protection planning. In this case, protecting the money from your kids. So again, when we talk about protection planning, we're trying to protect the money from any number of people. It could be, obviously, we talk about, I always tell people this planning we do comes down to 3 factors. The questions I ask is, who do you love, who do you trust, and how much you trust them? That question starts with, in the case of a married couple, how much you trust each other. Obviously, that's a question, sometimes difficult question I ask, how much do married couples trust each other? If something happens to one of them, what happens next? Things can be built into the plan to protect, your share of the assets if something happens to you if you're the deceased spouse. How can we protect money for your kids? Again, we just talked about how to protect the money from the kids, but, what we incorporate, and I know Harry's going to touch on this a little bit later, how can we protect the money for our kids in the sense of we can give the money, instead of giving money directly to our kids and exposing it to their creditors, we have a way through the revocable trust to protect the money for the kids so that they have lifetime asset protection from whatever they might inherit from you. We call it our dynasty trust planning. It's something we incorporate into your revocable trust. It's fairly straightforward, and something, if you decide to meet with someone like myself, we'll discuss in more detail, but it's a very simple way that the assets can be passed on to kids, and while they'll still maintain control and access to the money, it will not be exposed to their creditors, judgment, divorce, etc. So that's some of the basic planning that we get done through a revocable trust. And kind of what I do, and Harry's gonna, like I said, we're dealing with the foundation. Okay, the documents we do is typically what's called a revocable trust, a will, a power of attorney, a health directive. Those are the 4 foundational documents for most of our clients to make sure that we protect your family. Again, mostly protecting your family from having to go to court. Okay, the other documents get involved, or at least minimize the potential for going to court. Your will, as an example, again, while it doesn't directly protect, because actually a will is what goes to probate if that's all you have potentially. In order for the will to transfer control of assets from you to somebody else, that is what goes to court. Okay, but we have it as a backup document. It confirms the fact that your trust is the governing document for your assets. And so that's the purpose of the will. However, the will also, for those of us who have minor kids, it does have the purpose of naming backup guardians for our kids. But the guardian is the person who would take physical custody of our kids. And so while, again, that doesn't directly protect your family necessarily, it does hopefully avoid legal fights. If something happens to you and you have minor kids, we want to reduce the likelihood people are going to fight. And if you have a list of preferred, your preferred order of guardians that you tell a judge, that will probably hopefully discourage people from fighting about it. Okay. And so again, that doesn't directly save you money, but it does save your family money from hopefully anybody having a fight over who would take physical custody of your kids if something happened to the parents in this case. Power of attorney. As I always tell people, power of attorney health directive. Pretty much anybody over the age 18 needs those two documents, regardless of how much or how little money you have. We recommend to our clients, especially, we have a lot, clients who have college age kids. I know my kids, once they turn 18, the first thing I'm going to have them do is sign a power of attorney health directive, make sure somebody can make decisions for them when they cannot. Obviously, specifically in my case, my wife and I, that we can make decisions for them because once they turn 18, there is no automatics anymore. Okay, when they're minors, we can make decisions. We can take care of them. We make medical decisions. We have the authority. Once they turn 18, nobody has that authority. Even if you're married, your parents, your kids, nobody has actual legal authority to make decisions for you without written permission, and that's what we're providing you. We're providing somebody written permission that says this person has the authority to either make financial decisions for you through the power of attorney and or medical decisions through your healthcare directive. Because if you don't have these documents and something happens to you, you become incapacitated. Again, this is not about you passing on. You're incapacitated. Or in the case, for those of our elderly parents, dementia, something like that, again, they become incapacitated. We want to make sure somebody can make financial decisions for them. Somebody has authority to go to the bank, deal with government agencies, deal with a phone company. Again, so these are issues that have nothing to do with how much money you have. These are just basic life things that we do on a day-to-day basis. If we can't do those things for ourselves, somebody else got to do it. And if we don't have any documents like a power of attorney or health directive, somebody's going to have to get a conservatorship. Okay. Conservatorship is a court proceeding where somebody has to go to court and they, after, proving that in my case, if I don't have any documents, I become incapacitated. In order for somebody to have authority to either make financial decisions and legal decisions for me or medical decisions for me, they'll have to get a conservatorship of my estate in case of for assets or my person. And again, that's costly. And so and also I would at that point will have no control who's going to be my conservator. So again, that's another issue. I want to have control of that, and that's why I want to have documents. If I have something like a power of attorney or healthcare directive in place, somebody, if I become incapacitated, somebody can take over. Somebody of my choosing, most importantly. And they don't have to go to court. So again, saving my family money, and again, just as importantly, protecting me because I have somebody of my choosing in place. And at the end of the day, that's what these documents do. My goal in working with my clients is not only to make you have these documents, because everybody needs these documents, is to make sure that these documents are effective. I know one of the questions we got just from a person who I may or not be here today, they were questioning, well, if you have a will or trust, why are things going to probate? And that happens quite often. People have wills, in this case, a trust, thinking my family will avoid probate, and something happens, and it turns out the family finds out they're going to have to go to court because, in this case, the trust wasn't done properly. The trust wasn't properly funded. Okay, the assets were not properly in the trust, and that is something that's done after you sign your trust. And so there is work to be done. And an example, that's what we work with our clients once we get the trust set up for them. We're working with them either to do some of the work for them in terms of getting assets into their trust, like their home, business entities, and or their personal property, or working with the client to make sure they're doing what they need to do to make sure their accounts are either owned by the trust or the trust is the beneficiary. And that's an ongoing relationship we have with our clients, is try to make sure that we do everything we can within our power to make sure that our clients are doing that, because we won't know, as an example, if the client buys another house after they do the trust, we're not going to know they bought the house. And if we'll give them instructions how to buy that house under the trust, but if they don't do it and or don't come back to us to help put in the house in the trust, and something happens to them, that house is going to go to probate, and that's going to cost their family tens of thousands of dollars. Now, what we do as a firm is, we try to check in with our clients from time to time just to remind them about the documents and then be responsive to them. And that's because just as one of the bigger estate planning firms in Orange County, that's what we have our bandwidth. That's what we have capabilities doing, is the ability to check in and follow up with our clients. So we do everything we can as a firm to do, again, make sure your family's protected, as I always tell my clients, I never want to be, our focus is on estate planning and making sure your plan's effective. I never want my firm to be the reason why your plan's ineffective. And like I said, we're going to do everything we can to do that. And so, again, from the asset protection planning, well, we don't do the classic asset protection in the sense of, trying to, if you get sued, get in a car accident, make it harder for somebody to come after you. Asset protection, protection planning is beyond that. It's, Harry's going to talk about some of the protection on that end, but my end is the foundational part of it, in terms of preparing your base documents to make sure somebody's always in charge when you can't be, so that people aren't having to go to court. And that somebody we're choosing to charge. I mean, that's the other important part. That's, for me, that's probably the more important part of the protection planning, is making sure the people I trust are in charge, because we hear it all the time. Just today, I had somebody come in. They've, the wrong person's in charge, and we got we want to make sure the documents are in place to make sure the right person's in charge, because the wrong person's in charge, they may be ripping you off. And so we want to make sure documents, you get to choose who's in charge, because you know best who you trust. That's what this all comes down to on my end, is getting documents in place so that somebody you trust is in charge. With that being said, I'm going to pass this on to Paul and Harry and let them talk about what they do with their firm. We have an affiliate relationship with BarthCalderon. Like I said, we typically handle a lot of for our clients, we'll do a lot of the base planning, the estate planning. Quite often, if there's more extensive needs or more extensive asset protection planning, we refer them to Harry and his firm. But
Great.
I'll pass it on to Paul.
Great, Brian. Thank you. Great information. And Leslie and Brian, thank you for having us here. Hi, everybody. I'm Paul Hitchcock. I'm with the Asset Protection Advanced Estate Planning Business Planning firm BarthCalderon. Harry is our founder and senior managing partner. We're located in Orange County, California, in that building up there in the corner near Disneyland. Been there for many years. 12,000 clients across the country. We have about 35 attorneys at the firm. Harry is our top speaker, does these talks across the country. He's in very high demand for this. So treat this as access to Harry. There's going to be eye-opening information here on the asset protection side and how that's integrated with estate planning. And before we get to Harry, I want to mention something because it's in the chat there. Thank you, Leslie. For anybody that attends these webinars that we do, we always offer a complimentary assessment. We do that typically via a Zoom video call like this, or a phone call if you're not on video. There's a link in the chat. So if you want to get one-on-one with Harry and the team, click on that link, you fill out a form. It's just your name and email, so we can then get you booked with the right person. And those are great. You can get one-on-one. We can hear what's going on with you, with your planning. We can just get you organized and updated, and it all starts with that call. And so with that, Harry, I'm just going to hand it over to you. Let's go.
Oh, sounds great. Well, thank you, everybody. Thanks for being here. Thank you, Brian. Thank you, Paul. Thank you, Leslie. So first of all, let's talk a little bit about what Brian had to say. Brian's work is absolutely critical. I can't emphasize that enough. Brian talks about court and leaving people in charge, but I'm going to put Brian in a slightly different position. Let's make Brian the director of a play, and let's sit in the theater, and let's put your whole family, your children, your grandchildren, your brothers, your sisters, let's put the whole family on the stage. And let's have Brian sit with you in the theater, and let's write a script for what that play is going to look like after you pass. So not only do we avoid the court, not only do we put people in charge, but we say how those people will be in charge. We say how they will receive the money. We will say when they receive their money. They'll talk about whether or not they have drug, alcohol, or addiction problems. We'll decide whether they're going to fight or they're not going to fight. Brian's work as a script writer is absolutely fundamental. I want to make that very, very important, because our work begins where his work leaves off. So that's critical. So let's talk a little bit, as we could, about asset protection. And people don't understand what asset protection is, so we're going to kind of explain that a little bit. And we're going to talk a little bit how Brian's work makes sure that there is asset protection for the next generation as well. So Let's start with a simple adage. Who doesn't want to protect their assets? Who wants to go to court? Nobody does. I asked that universally for 45 years. Do you want to protect your assets, your home, your bank account? Of course I do. So everybody does when we form LLCs, we form corporations, we buy life insurance, we buy car insurance, we buy homeowners insurance, all to protect our assets. So everybody wants to protect their assets. The difference is that what is asset protection is the way in which we organize our assets that level the playing field. The playing field is not level. All right. And so we're going to talk a little bit about the reason behind asset protection, how we level the playing field, and how our work integrates with Brian's work to make your family more secure today and tomorrow. Now let's think about this. Brian does a great job. Brian builds a beautiful, or as Trump would say, a big, beautiful estate plan. And everything is appropriately funded. And you have the right people in charge and trustees, and we've avoided probate. But what we didn't avoid was the terrible car accident that happened that's your fault. And so several people were killed or some people were injured. And now you're being sued, and the liability is well in excess of your insurance. And now there are no assets to move through Brian's structure because they're all gone. They went to a creditor, a judgment creditor. So we see this many times where people have beautiful estate plans, but they lost their assets that belong inside that. So what we're going to talk about today is how could one best protect their assets. But there are three rules that are critically important, one of which Brian hit upon. So the first of the rules is that you don't engage in asset protection planning after the fact. As Paul said, we have 12,000 clients. I've been at this for close to 45 years. And we get calls, you can imagine, 3-4 times a week to our firm because we're well known in the asset protection arena. Harry, Paul, this happened. My wife had a crash. My husband had a crash. My husband's being sued, for a disability violation, a wage and hour problem at the company, whatever it may be. What can you do to help us protect ourselves? We've worked hard for all our lives, and we don't want to lose everything that we got. And this is not the time to be calling. Right. So the first thing that's important to understand is that asset protection planning needs to happen when there are no liabilities, when there are no storm clouds in the sky. That's when it's most effective. Now, that doesn't necessarily mean that if we have a problem that everything is tied up. You might have $10 million worth of assets and $1 million worth of liability. We could still work with the other 9 million. All right. And we could slow people down on the million and hopefully get a better settlement. But to be effective, asset protection planning needs to be done before the liability arises. Now, that in your terms, when you think about that, here's what we hear. Well, we haven't heard from the lawyer yet. We haven't been sued yet. So I guess we're okay. No, you're not okay. It's when the liability arose, when the car crash happened. You may not hear from a lawyer from a year. You may not hear from a lawyer for a year and a half. You might not get a letter for 6 months. But it's when the liability, the facts that gave rise to the liability arose is the dividing line as to when that particular liability can be protected or not protected. So that's very important to understand. The second important part Brian hit upon, and that is living revocable trusts. All right. Brian does beautiful living revocable trusts. They're well constructed. We've seen them. They're amazing. But one thing, as Brian pointed out, and I want to make it very clear to all of you, that living revocable trusts, the ones that avoid probate, all right, the ones that give the family direction, do not protect any of your assets from the claims of third-party creditors. They are not asset protection trusts. We hear this from clients as well. Well, Brian set up a trust for us and we have our house in the trust, so it's protected, right? And the answer is no. If you can gain access to that trust, if you can have the flexibility that Brian built into that trust, all the assets in that trust are generally available to the claims of creditors. So that's an urban myth that we need to dispel. Very important document, but not an asset protection document. And the third component when we talk about today is that I have insurance for that. I have insurance on top of insurance. I have umbrellas on top of umbrellas. I have plenty of insurance that I'm not too worried about protecting my assets by means of legal procedure. Well, that's a really bad scenario. And let's talk about that for a second. Insurance is critically important and a very important part of asset protection. It's the place where we want to drive a creditor to. We want the pot of gold at the end of the rainbow to pay for the defense, to get things done. Insurance is critically important. But when I speak with clients and clients come in or potential clients come in and say, oh, I have a $3 million personal umbrella liability contract. What are they saying? They're saying, we don't believe that we will have a liability that's in excess of the insurance that we bought. So even though we may have $7 or $8 million worth of assets, which is pretty easy to accumulate today in California, what do we do if the amount of the liability is above the $3 million? What if it's a $4.2 million judgment and we have $3 million worth of coverage? Where does the $1.2 million going to come from? People don't realize that. They seem to think that in our legal profession, whether Brian and I do, that the lawyers, that are on the billboards are only going to take from you that which the insurance company offers. Well, that's not true. They will take from you whatever is easy and they can prove by their judgment and get their percentage along the way. So insurance has a lot of holes in it. Doesn't cover punitive damages, exemplary damages, special damages. It doesn't cover excess. And there's just a lot of things that are not covered by insurance. It's critically important, but it's not the know-all end-all. So 3 important axioms before we get into specifics. 1, not after the fact. 2, your important living revocable trust does not provide any asset protection. And 3, insurance, although critically important, is not the know-all end-all. And we're going to try to give you basic things today and how to protect those assets. But let's understand from a fundamental point of view, well, how big of a problem is this? Well, let's take a few things to guess. So the first thing, let's take a guess on how many lawsuits were filed in the United States of America last year. The number is absolutely astounding. I know.
40 million. 40 million.
Yeah, it's actually 50 million.
50 million.
50 million lawsuits were filed in the United States of America last year. Now remember, every divorce action, lawsuit. Every tax action, lawsuit. Every criminal action, lawsuit. Every immigration action, lawsuit. Every environmental action, lawsuit. Every time we ask the judicial branch of government to resolve a dispute, it begins with a complaint. 50 million lawsuits per year. That's absolutely amazing. But there's a more amazing statistic, because I practice not only in California and New York and Washington, I also practice in a couple other countries as well. And then here's something that to think about. 95%, Leslie, think about this, 95% of all litigation in the world occurs in the United States of America. Only 5% occurs outside of the United States of America. What the heck is the story about that? And why does that happen? And that tale is very, very important to us today. Why is that? Well, start with the fact that we are still and remain still at the moment the largest economic engine in the world. We have the most corporations, the most LLCs. We have a lot of laws. We're the place where people come from all over the world to do capitalism and commerce. So we're going to have more disputes than any other place. So that's one of the reasons that we have it. We are the place. But there are some other reasons too. Now, one of the other reasons is that in a lawsuit, who pays? Who pays the lawyer? All right. So in most countries around the world, the loser pays the winner's legal fees. So if I bring a lawsuit against Brian and it's a frivolous action against Brian, and I can't make my case after putting him through a bunch of stuff, and he had to spend $150,000 on lawyers, and I lose, I'm going to have to pay Brian's legal fees. I caused that problem for him with a meritless case. That's called the British system. The American system is everybody pays their own lawyers. So if I bring a frivolous case against Brian, all right, and many times Brian's going to turn around and say, look, I'll just give you $50,000, go away. All right. It's going to cost me $100,000 to defend myself. I'll give you $50,000, go away. So the fact that the loser does not pay in America contributes to that 95% in the world. The other thing too is the mindset. You know, in around the world, people take responsibility in many cases for their own actions. In the United States, there's a lot of finger pointing. Everyone's to blame for something. Hamburgers made me too fat. All right, I'm smoking cigarettes, but it's the cigarette manufacturer's problem, not my problem. Um, you know, we just don't have a form of any form of responsibility. People want to win the lawsuit lottery. So with that societal impact that any little thing goes wrong, call the lawyer, they sue. Um, that's problematic. But there's another one, and it's a big one. It's called contingency fees. All the billboard guys and girls, we see them on the freeways. We drive up and down. It used to be at nighttime, ladies and gentlemen. It was Cal Worthington selling Fords and stuff at night on late night TV. Now all we see on late night TV is, Sweet James and Morgan and Eaton, and Russ Brown. You go down, the Motorcycle Brothers, the Accident Brothers, whatever it may be. All we see is these. And why? Because there is now in contingency fees. And contingency fees basically is that, hey, we partner with a lawyer, all right? That lawyer takes 30, 40% of whatever they can collect. You don't pay anything unless they win, all right? So victim has no skin in the game. It's the lawyers. Now, this started, ladies and gentlemen, as a very good idea. The American legal system is expensive. We may not want to think so, but it is. It's expensive. It's an expensive business to run. It's an expensive business. And so, therefore, the access to the good aspects of our legal system are very limited. People of low income and moderate income don't have the ability to hire lawyers when they're actually injured or become victims. So we came up with this contingency fee system where we'll allow you to partner with a law firm. And hey, guess what? There you go. You got a good law firm and you share fees with them should they be successful in your case. Now, that started off as a great and noble idea, but it turned into a multi-billion-dollar industry that for every little thing, the water is bad at Camp Lejeune. The weed killer is no good. This is not good. This drug is bad. Did you drink tap water from this city? It goes on. They're called mass torts and contingency fees. And this multi-billion-dollar industry combined with punitive damages, special damages, and exemplary damages have just left the judicial system in the United States running amok. And it has run amok. 50 million lawsuits, 95% in America. And these are the reasons why. Given that is there, we're going to talk a little bit about the fact that asset protection, ladies and gentlemen, is not new. All of these attorneys and these law firms, they know very well. They've gone to school for years and years and years. They know very well how to use the law to reach your assets and get the money that they need for their client. They're very, very good at it. But some of us, Brian and myself, we know how to use the law to protect you from them. So you need to make sure that you have people who are setting up things and walls to protect you. Let me bring it into something that's a little bit more of an analogy that we can relate to, and then we'll go to some specifics along the way. So let's go back in the Middle Ages and let's say, hey, Brian and Paul and Leslie, we were all a marauding army and we're running around and we're fighting a war for the last 20 some odd years. And we fight this war and we're successful. So we win. And if the result of winning, we spent a lot of time fighting the war. We lost limbs fighting the war. We spent a lot of money fighting the war. We even lost lives in fighting the war. But we won, so we are entitled to the spoils of war. So Leslie takes a big bag full of treasure and puts it on her back, and she brings it back to her home. And let's say her home looks like Hobbit land from Lord of the Rings. Oh, it's a beautiful place. The grass is green, the skies are blue, the clouds look like marshmallows. We have cobblestone streets, really nice. Instead of calling it Hobbit land, we're going to call it Naiveville. And Leslie takes everything that she worked so hard for over the last 20 years and lays it down in the plaza in the center of her little village back in the Middle Ages. You know what's going to happen? All the robber barons and the barbarians are going to come out of the forest and they're going to steal all her stuff, everything she worked all her life for. So back then they said, well, maybe we ought to engage in some asset protection planning. Don't have to take it from me. Take a trip to merry old England. And what will you see? You will see a castle with big, thick walls. And that which was important to them, that was worked so hard for, was put behind those big walls to protect them. But was it enough to just have big, thick walls? No. They dug a moat. And they, what was in the moat? Water, because it was more difficult to pass the water before you got to the walls. And allegedly, what was inside that moat? Pit vipers, alligators, crocodiles. How they got them in merry old England, I have absolutely no idea, but they did. And then there was always Mel Gibson sitting on top, boiling oil down the walls to keep everybody away. And the hope was that when the robber barons came, or the barbarians came, they would see the fortifications and go to a place that was less fortified. It's there. It was asset protection. It's no different today. When the lawyers come, God forbid we have a liability, and none of us want a liability. We're not risky people, but we drive cars. We own real estate. We own houses. We may have a dog. It doesn't matter what we have. We may be in a position as a physician or an attorney or a pharmacist, and we fill the bill the wrong way. We do something wrong. We didn't mean to do it. And now we're personally liable to the full extent of our net worth. We need to do some things and build some walls to have us protected. So, one of the things that Brian alluded to, let me talk about now. So, one of the things that's very important in the work that he does, that's critically important, is how we transition money from parents to children. And let's talk about that. So my wife and I, we have two children, and upon my wife and I passing, if we just turn around and take our assets, then give them outright to our children, it becomes part of the children's estate. It becomes subject to all of their claims of creditors. So if a child turns around and crashes the car and kills two people, they can reach that money. If a child spouse, wants to have an impact on that money, they can. If a child signs personal guarantees or does, big bad business deals, they can reach all that money. Everything my wife and I worked all our life for, when it reaches our children, is completely exposed and protected. So if Brian, they get it at 25, that happens at 25. It's okay. So Brian alluded to what he called his dynastic work. So basically, let's just talk about that for a second from an asset protection point of view. So instead of my two kids, Brad and Amy, instead of leaving them their assets directly to them, I left it to them in a trust for them for their lives. And I put Amy in charge of her trust and Brad in charge of his trust. So they had complete control of the assets. They had the ability to make investments, buy houses, start businesses, do what they needed to do in the trust. But with appropriate and proper design, all of those external creditors could not reach those assets. And if you ask children how they would like to receive their assets, the vast majority of time they say we would like to receive it in a protected silo. So there are lots of ways to do that. So very, very important when you're speaking to Brian and dealing with your foundational trust documents, let's consider the asset protection for the next generation. Brian could do a good job in making sure that those kids are protected from liabilities that they face. It's relatively easy to do. As Brian said, it's kind of straightforward. And
Hey,
so,
quick thing I want to say, because
sure,
this is a joint
sure.
client with Brian, is I'm looking at the email now, and this was two brothers, parents died, assets are transferring. One of the brothers has an outstanding liability. He's got a judgment against them. They're transferring a $1.8 million property. This is exactly what you're talking about. They're asking, we're scared because what's going to happen with that judgment if my brother gets half of this $1.8 million house, right?
Well, the answer is kind of real simple. That judgment creditor, if that is not in trust, will be able to reach that property.
Yeah.
Yeah,
Yep.
it's that simple. Now, had they received that one half of that property in trust or an appropriately and properly designed LLC in trust, they would not be able to reach that property. So it depends on how. One of the things I always talk about is, let's say my spouse inherited from her parents a small cabin on the shores of Lake Tahoe. It's been in the family for 2 generations. And then, so she inherits this property. It was great. It was got an outright disposition when her parents died. So the family tradition is to continue to use that property up in Lake Tahoe. But if my wife turns around and crashes the car and kills a couple people, God forbid, it can happen to any one of us. That's her asset. All right. And they can actually take that asset and sell that asset to satisfy that claim. It would have been a lot nicer if she had parents had left that asset in trust for the benefit of my wife and family. Then could have used the property. She could have sold her everything in trust, and the creditors would not have been able to reach it. It was a simple determination on how we leave assets to the next generation. And I think that's critically important. So when you're working with Brian, you got to turn around and talk a little bit about, okay, how do we protect the kids? And now that they're kids, and how do they protect the kids from themselves? But let's talk about a few other things from an asset protection perspective. One of the things that are critically important for us, for most of us, is our homes. All right, so let's talk about what the story is with homes. And I go and I speak all around California, and I ask people, well, do you think if you have a liability, husband and wife, or spouse and spouse, um, you lose your home or keep your home? And most people say, well, we keep our house. Our house is safe. And I say, you think so, huh? Well, maybe it is in Texas, maybe it is in Florida, maybe it is in Kansas. But here are the rules in California. First of all, spouses. Let's talk about spouses. A spousal liability, a liability of one spouse is the liability of the other spouse as a result of our community property system. A lot of people think community property is 50-50. It is when we divide community property in the event of a dissolution of marriage, but it's 100% during the course of the marriage that it's available for community property is there to satisfy a community liability. And when I crashed the car, it's the same as my wife crashed the car. So now they're looking down at my separate property assets, and they're looking at our community assets to satisfy this claim, anything that's not paid for by insurance. But remember, I don't want to give them a lot of incentive to go past the insurance and go after my personal assets. But if I make it easy, they get it. So a lot of people they bought their houses, for 600,000 and seven. Today those houses are $2 million. All right, in California. So if one has a $2 million house in California and they have a $500,000 mortgage on it, we've got $1.5 million worth of equity in our property. Okay, so what's the rules? People don't know the rules, so let's learn the rules of what happens. In November, in the year of the pandemic, California changed their homestead exemption rules. It used to be as follows. If you were a single person residing in a home, $75,000 of equity was exempt from the claims of creditors. Well, whoopee-doo, a lot of money there. If one was married, it was $100,000 of equity was exempt from the claims of creditors. And if one was over age 65 and or a disabled person lived in the house, it was $175,000 of equity was exempt. So if we had more than that amount of equity in our home, they would take our home, sell our home on the courthouse steps, and give you a check for $100,000. Well, they really got concerned about that during the pandemic, and they thought that there was going to be a bunch of homeless people in California. And that's the only reason why it wasn't to protect us. They changed the homestead laws. So let's go what they are. So now in California, the homestead laws start with a minimum of $300,000 and can rise as high as $722,000. It's no longer dependent on marital status or disability. The amount that is exempt is based upon the average median value of a house in the county that you live in. So in Orange County, the median is like $1.2 million. So we have the full 722,000. Same thing in LA, same thing in San Diego County. In San Bernardino, Riverside, we run at about $650,000 homestead exemption. So now if we have more than $722,000 of equity in our home, as many of us do, our home is lost. And it doesn't matter whether Brian put it into trust or not. That avoids probate, says what happens to the house, but will you still have a house if, God forbid, there was a liability? So one of the first things, again, like I said, make sure we have adequate insurance. I mean, let me give you an example. So I look at people that have insurance and they have liability insurance, associated with their home or personal insurance. Brian, it's at $300,000, maybe $500,000. Well, I got news for you. My son went in for an appendectomy in a hospital, and it was $175,000, $80,000, $100,000. I mean, that's nothing today. One should have at least $1 million, $2 million worth of liability coverage to protect them. If we don't, we have a damn good chance that we'll lose our home. So one of the things we want to talk about is I just want you to understand the vulnerability that all of our homes are in California. And you ask the question whether it happens, whether homes are lost all day long. Go to the courthouse steps all day long, people losing homes. Here's your check for $722,000. We sold a home for $2 million. There was $500,000 in excess of the exemption amount that can go towards the claim. And then people, of course, are all panicked. How could that happen? How could that happen? How could that happen? Okay. So there are tools, qualified personal residence trust, residential shield trusts, and other types of things that we can, procedures that we can engage in that can help put fencing around the house for asset protection purposes beyond the time that we have to go through today. Just understand that there are ways that we can protect your home, and you should at least consider them. Very important. But let's talk about something else that Brian talked about, and let's talk about life insurance for a second. So many of us have life insurance, all right? And life insurance is a very interesting asset. So Brian, that tells you got life insurance. He takes the beneficiary of the life insurance and make a trust, and we bought the life insurance for two reasons. One reason we buy life insurance is that there's a premature death. There's money to take care of the spouse and the children, critically important. And the other reason that a lot of people buy permanent forms of life insurance is to accumulate cash values inside life insurance, because all of the cash values that are built up inside life insurance contracts are not subject to current income tax. And we have the ability to access them through policy loans, which is not a taxable event. So people are accumulating a lot of money sometimes in life insurance policies to have a supplemental retirement plan. So I ask when I go around, and I would say, how is our life insurance protected or not protected under California law if we have a liability? All right. So again, my wife crashed a car. There, people aren't getting up. Oh my God. There's going to be, you get a letter from the insurance company that says, hey, Mr. Chu, looks like you have a liability here, and it says, looks like your liability is going to be in excess of the coverage that you have. Call your lawyer. All right. That they actually write that letter a little bit late in the game, don't you think? The crash occurred. We got the insurance company saying you ain't got enough insurance. Call your lawyer. Like, what's your lawyer going to do at this point in time? But here's what happens. So let's take a look at life insurance. So the first thing we have to take a look at is there's the cash values that are inside those life insurance policies that we have. And when you look at those cash values, you say, are they protected? Well, in almost every state, the life insurance cash values in a policy are protected from the claims of creditors as a matter of public policy, but not in California. So in California, here is the rules. In a family, each spouse gets a $17,000 exemption for cash values. They can combine them together for $34,000. If we have life insurance cash values that are in excess of $34,000, the creditor can reach the life insurance. Ugh, that's not real good. We got this to protect the spouse and the children, and now they'll be able to take it away. But here is the one that's a little bit more concerning. So that's an issue and a problem. So Brian may suggest to you at that point, maybe there should be do something to protect those life insurance cash values, especially if you have significant amount of money that's inside of it. But the other concern is this, and this one is devious, and I want everyone to understand it. In every state but California, the death benefit of a life insurance policy is exempt from the claims of creditors. God forbid, in that accident, I was killed. All right. I hit two people, it was my fault. Then I went into a pole, I was killed, and my $3 million life insurance policy paid off for the benefit of my life and my children. Ugh. So you would think that that's protected. In every state, they say, as a result of death, if we have spouse and children named as direct beneficiaries or the trust, Brian, we're okay, we're good. Not California. California says that the amount of the death benefit that's exempt from the claims of creditors is the amount in a judicial determination, back in Brian's favorite probate court. The amount is determined as the amount that's reasonable and necessary for the support of the children and the spouse. And it's pretty stingy. So you might have $3 million worth of life insurance, but if the court determines only 1.5 million is necessary for your family, they'll give the other 1.5 million to the creditor. This is the only state that does that. So solution, hey, how about putting the life insurance into a life insurance trust? We put the life insurance into a life insurance trust. Brian and I coordinate that for you. Then guess what? The life insurance isn't in your estate. Brian, the cash value is protected from the claims of creditors. They can't get it, even though I have 400,000 of cash values. And on top of that, the death proceeds are always protected for my family. So not a bad thing for consideration for us. Now, on that note, let's move forward just a little bit. In the few minutes that I have left, there are about 15 classes of assets that I could cover for you, but we'll have to do them in subsequent consultations or in subsequent meetings with Brian and his team. But let's talk a little bit about 401k plans, IRAs, pension plans, 453 plans, SEP IRAs. We all have retirement plans. And we all seem to believe that our retirement plans are exempt from the claims of creditors. And the answer is maybe. So let's learn about that. So under federal law, an ERISA qualified plan. So there's qualified plans and ERISA qualified plans, Employee Retirement Income Security Act of 1974. Under an ERISA plan, all right, which the way that you could determine that, ladies and gentlemen, you have at least one participating employee in the plan that's not your spouse or your child, all right? And under them, the retirement plan is 100% exempt from the claims of creditors. O.J. Simpson had $25 million worth of assets in the NFL pension, and in his business pension plans, not one penny of that was ever able to be touched by the Brown and Goldman family. So an ERISA qualified plan is exempt from the claims of creditors. Now, an IRA that we have, Roth IRA, we don't have any employees, all right? We've been putting the money in $2,000, $3,000, $5,000 a year, or a SEP IRA is a qualified plan, but not an ERISA qualified plan. So a lot of people have a couple $100,000, $250,000 sitting in their IRA. Now you work with Brian, and Brian worked out how the beneficiary should be structured. Maybe spouse first for IRA rollovers, and maybe trust second. Brian and his team will help you deal with how the beneficiary should be structured. But we want to know how that particular asset fares under California law. It's the same as the life insurance. If it's not an ERISA qualified plan, but a qualified plan, the amount that's exempt from the claims of creditors is the amount that's reasonable and necessary for the support of the family in a judicial determination. Again, in most every state, they treat that the same as an ERISA qualified plan, but not in California. The problem that we face, if I have $200,000, Brian, in your IRA, and I can get to that IRA because the court says, Brian, you got a lot of other stuff. You're a good lawyer. You make a lot of money. I'm giving that $200,000 to the creditor. Not only do the $200,000 go to the creditor, you get the privilege, Brian, of paying the income tax on the $200,000 and a penalty. So, not only do you lose the 200 grand, you got to wind up paying close to $130,000 worth of taxes. That probably money that you don't have. It's a disaster. So we need to take a look at that. But there's something else that's critically important for all of you to understand, and that is, even if it's an ERISA qualified plan and protected plan, and if it's not, what are the things that we can do to protect our IRA in California? And there are certain steps that we can do to help protect those assets. Is how do I use that money if I have, I have a creditor that's all over me? If I take money out of that protected environment, out of my 401k to pay some bills or whatever else I got to do, I know I got to pay tax on it. Can the creditor get that money? So that depends on state law. And here are the 3 state laws. One, Brian, when you took it out of the protected environment and gave it to you, and I have a judgment against you, bye-bye. All right, I get the money. Once it comes out of the protected environment, if I haven't settled it, I haven't filed bankruptcy, I haven't settled the claim, that money now goes to the creditor. Other states turn around and say, well, what that really is, guys, is deferred wages. You deferred, money, into the 401k plan, whatever else it may be. So when you take it out, it's the same as wages and subject to the California's wage garnishment laws, which means you can keep 75%, Leslie, but 25% of it has to go to the creditor. And some states say if the tree is exempt, then the fruit of the tree is exempt. Believe it or not, California is the third. If it's an exempt ERISA qualified plan, you can take all the money out of it. If we could trace it back to that exempt plan, it still keeps its exemption. So if Leslie, you took out $300,000 from your retirement plan with 401k and bought a boat with it, we call it the HMS Leslie, okay? And now I want to hey, I had a $300,000 boat. I want to sell that boat for credit. Say, no, I bought that boat with $300,000 from my retirement plan. It remains safe in California. So an analysis of the retirement plans and how to protect them becomes critically important from an asset protection perspective. And last but not least, in just the 5 minutes that I have left, ladies and gentlemen, for any of you that have rental property, I don't know, rent apartment building, rent a house, rent any real estate, please, 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 even though if you put it in your trust, fine, it avoids probate. It avoids probate, all across the country. It's perfect to do it, but there's no asset protection. And the liability comes two different ways. Landlord tenant liability. And although your trust is the landlord, that has no asset protection, so it ends with your bankruptcy. So landlord tenant is unlimited liability. Second, a liability to Brian. If I get a liability against Brian and Brian's got properties inside his trust, just in his trust name, I can go into your trust, Brian, take those properties, sell them on the courthouse steps, and use that equity to pay the creditor. Now, change it just a little bit with me for a moment. Simply take that same piece of real property that's worth, call it $800,000. It's the old house that has a $200,000 mortgage left on it with $600,000 of equity. And I put it inside an appropriately and properly designed limited liability company in an LLC. And then Brian takes that LLC and puts that LLC inside your trust. So we avoid probate, Brian. No problem. Don't go to court. All the trustees, all the things that Brian told us are still there and good. There will be no reassessment when done properly. There will be no problems, but here's the difference. If I have a landlord-tenant liability, it ends at the value of the property and not your entire net worth. Your retirement plan is not touched, your house is not touched, your savings account is not touched, your other rental properties are not touched, it ends. So if I have a $400,000 worth of equity that's in that LLC, I don't care if it's a $2 million judgment, the maximum I can get is $400,000. Wow, what a difference. And if structured properly in a good jurisdiction, ladies and gentlemen, I won't be able, Brian, if you have that liability, I won't be able to go in and take your property away from you. I'll be able to put a lien over distributions from that property, but I won't be able to go in and sell that property on the courthouse steps, allowing us to level the playing field and allowing us to try to settle this thing within insurance policy limits. Well, there are so many more things. There are probably 20 or 30 other things that I can share with all of you, but we can't do it today because we have time limitations. I appreciate the time, Leslie and Brian, being with you today. I appreciate everybody who's with us. We are available to answer any and all of your questions through Brian's office or directly with our office in coordination with Brian and his team at O.C. Wilson Trust. They're the best. And we look forward as a team to helping each and every one of you achieve both your estate planning goals and your asset protection goals. So I thank you all very much for having me today. Appreciate it.
Thank you, Harry.
Oh, you're welcome.
Are there any questions or from everyone? Are there any questions? Because this would be a good time.
I got one question that was sent in before the event. So Brian and Harry, if you want to set up if you want to protect your assets, transferring them to your children, then is it the irrevocable trust that can receive the assets is set up during the parent's lifetime, and it's part of their trust? How does that play out?
No. So Brian sets up the trust, which is revocable, and that trust becomes irrevocable upon the parent's death. So now we have
Okay.
irrevocable trust for the children. So we don't, although there is a time and a place for irrevocable trust if we're transferring assets to children during lifetime, we want to get them out of the estate and for some asset protection purposes. But traditionally, it's set up, as your basic foundational living revocable trust, and which becomes irrevocable on death. A lot of people don't realize it changes, upon death.
Is that true for a special needs trust if you have a child with a disability or so forth?
Absolutely. And especially in a special needs trust that's set up, there are two types of special needs trust: the first party special needs trust and a third party special needs trust. Most situations we see is that parents are setting up a trust for the benefit of their children when they pass. So the children have, special benefits from the government. We don't want them to lose them when they inherit dollars. Kids have no money now. But now Brian dies, and now his kids have millions of dollars. They would lose all their benefits if they had special needs. So now we create a special needs trust, which is under the living revocable trust that Brian creates, and that protects that money from the state and from the federal government, so they don't lose their valuable government benefits, although their life became a lot better because they inherited. A first party special needs trust is created actually by a court. Okay. So when, someone, a 21, 22-year-old, God forbid, is in a car accident and they're just not functioning very well anymore, and they receive an award from the contingency fee lawyers that they hired, and they put that into a first party special needs trust. That's the same kind of concept in that they don't allow the government to go in and take that money that they got as a result of that personal injury and knock them off of their government benefits. So
Got it.
two different kinds, but the same principle at the end is protecting valuable government benefits for an injured or a special needs beneficiary.
Okay. Well, Leslie and Brian, thank you very much for having
Oh,
us.
thank you for
Thank you, guys.
joining
It was
us.
Take care.
great. We look forward to many more, and thank you very, very much for the opportunity. Take care, guys.
Yes,
Thank you.
Yeah, thank you,
Bye.
everybody.
thank you
All right.
all.
Thank you for attending today's. Hopefully you found this informational, and we'll be doing this as an ongoing series in addition to our standard estate planning workshops that I do on a monthly basis. We'll be doing these kind of specialty topics as we go along, and that'll be for our new clients or existing clients. If you know people that would benefit from from these various topics, just contact us. If you're already our client, you'll be getting email notifications, but also through our website, you can also be notified of upcoming workshops.